¿Qué tal, mi gente? Hablando de temas migratorios, yo soy la abogada María Mendoza, abogada de inmigración, y we're going to be speaking in English. We're going to be talking about USCIS adding more special agents that will carry firearms, that will be devoted to fraud detection. We're going to talk about how that's going to affect VAWA. No se me vayan.
La abogada de imposibles, así le llaman algunos, pues la fe tenían perdida y María les demostró que con un poco de fe todo se puede, Señor. Y la lucha sigue con la abogada María Mendoza.
¿Qué tal de nuevo? Soy la abogada María Mendoza. This time we're doing one of my first videos in English, so it feels a little weird, so just bear with me. USCIS has announced recently that they've added new special agents that are going to be focused on ensuring or prosecuting persons that violate immigration laws. Some of these special agents are going to be permitted to carry firearms. And there's also going to be resources devoted to fraud allocation with these new special agents. And I want to talk to you about this issue of VAWA fraud because there's a lot of controversy over VAWA fraud, what it is, what it isn't. So let's talk about it. Let's talk about what fraud is realistically from a legal sense. From a legal sense, VAWA fraud is when you lie about your case. You lie about your case, you produce fraudulent evidence, you exaggerate your case, you distort your case, you make something up. So for example, let's say I'm filing for VAWA based off of abuse from my US citizen husband, but we actually have a good marriage together, and I lie to my attorney and say that he beats me up or that he rapes me. Or I tell my lawyer, hey, I have proof that he beats me up, and I punch myself in the face and send my lawyer a picture of a black eye and say, hey, I got it when my husband beat me up, but realistically, I manufactured the evidence because I punched myself. That's a good example of VAWA fraud. There's also a lot of information in social media and the news about lawyers helping their clients commit VAWA fraud. And I want to talk to you about a famous case of when that happened, or a recent case of where that happened. And I also want to talk to you guys about what to look for with these particular types of cases. So in this particular case, this is the case of the lawyer. His name was Coffee, guy out of New York City. And he was helping people file VAWAs, but part of his legal advice to the clients was that they didn't qualify for VAWA. And what he was doing was he was filing VAWA with the residency to get something called the travel permit, el permiso de viaje. And with the permiso de viaje, the travel permit, the clients would leave the United States, come back to the United States, but with the travel permit, they can get una estampilla, they could get their passport stamped. And with that stamped passport, that parole, he would file for an adjustment of status. Now, he got in trouble because he explained this strategy to an undercover agent from the Department of Justice and basically explained to them that they did not qualify for VAWA and that this was a loophole for him, and explained his strategy. That is VAWA fraud. If you file VAWA and your attorney advises you that you don't qualify for VAWA, that it's a loophole, and this is what's key. Let's say that you have to, usually in VAWA applications, you have to submit a declaration, which is like your testimony, where you discuss the abuse in detail. If the lawyer guides you on how to lie, like, hey, you're going to have to say your husband hit you, you're going to have to say he raped you, you're going to have to say he strangled you, this is how I recommend you say it, I might recommend some evidence, send me some pictures of some black eyes, you're going to have to inflict them on yourself. That is classic fraud. That is classic fraud. And the penalty of this is not only that your case could get denied, it's not only that you can be permanently barred, you can have a castigo permanente, a permanent bar from being able to apply for relief, but we're talking jail time. We're talking that you could go to jail for this, and your lawyer, if your lawyer does this type of things where they're telling you, advising you to lie, advising you to manufacture evidence, advising you to exaggerate, your lawyer could go to jail. So that is what VAWA fraud is. That's the most classic, basic form of VAWA fraud. Now, I hear on social media a lot of attorneys and persons saying that people are committing VAWA fraud, and I'm not sure that that's actually true. And I'm not sure exactly where all of it comes from, because I think it comes from different sources. But I think on one hand, a lot of attorneys don't believe that people suffer domestic violence to the extent that people really do suffer domestic violence. So I think maybe a lot of attorneys assume that people are lying because they don't understand how unfortunately common it is that someone suffers domestic violence. And then there's a lot of attorneys that sort of take on maybe not necessarily fraudulent cases, but extremely weak, extremely exaggerated cases. And those extremely weak, extremely exaggerated cases are also things you want to be very, very careful with, because USCIS is cracking down on these cases. They're cracking down on fraud, and you don't want to be put in a position where a lawyer filed a petition that they shouldn't have filed, and then they're sort of pressuring you, or you feel pressured to, as us Mexicans say, echar crema en los tacos, exaggerate your case to make it worthwhile. I hear a lot of attorneys on social media say, and I've heard it from the consultas, people say that the lawyer said that VAWA is basado en problemillas, basado en pequeñas indiferencias, basado en problemas matrimoniales comunes. VAWA is not based off of slight indifferences. VAWA is not based off of some minor disagreements. VAWA is not based off of the everyday problems that somebody has with their adult child, nor the everyday problems that everyone has. Everyone has problems with their spouse, and everyone has problems with their U.S. citizen child. And if they tell you that they don't, then they're probably lying. Problems. So, and it's hard to kind of give a rule because every case is different, and you really have to look at the behavior of the abuser and determine whether it's enough. Have we crossed a line? Is this just problemillas de la vida, problemillas normales, problemillas de cualquier persona tiene, or is this abuse? So let's take a couple of examples of things I've heard. My spouse doesn't want to take a picture with me. My spouse likes other girls' pictures on Instagram. That's not abuse. Those are common problems that, some couples have, but that is not abuse. I joke with everyone. If your wife doesn't pack you lunch, if she burns the beans, si los frijoles son quemados, that's not abuse. Those are common everyday problems that maybe not everyone has with their spouse. If your adult child, U.S. citizen child over the age of 21 yells at you, do they yell at you every day? And how do they yell at you every day? Then maybe you're meeting one of the elements of VAWA. If they yell at you every 6 months, that's probably not abuse. That's probably just everyday problems. If the case feels like a real stretch, then you're probably getting into a situation where it's really not meeting the legal standard, because the legal standard is based off of extreme abuse. In order to qualify for VAWA, it can be emotional abuse, it can be psychological abuse, it can be verbal abuse, it can be physical abuse, it can be sexual abuse, but it needs to be abuse. And let's not pretend. I think that's where a lot of people are getting into trouble, is that maybe there's lawyers that are willing to take a case and sort of take a case with problemillas normales, everyday problems, and try to make it out to something that it's not. And that, I don't know if that's necessarily fraud if they're not lying. It might just be a very weak case, or a case that didn't really meet the requirements, the eligibility requirements to file for VAWA. I don't know what they're doing, but let's be clear. VAWA has to be based off of abuse. Some of the cases that I see that are the strongest forms of abuse, for people applying based off of marriage to a U.S. citizen or a lawful permanent resident, there typically is some level of either physical or sexual abuse. And a lot of people say, oh, no, there's no hay golpes, no hay violencia física. But when we interview the clients, we find out that there is physical violence. And it might not be everyday physical violence, but there's been times where they've been hit. There's a lot of issues of sexual abuse. Something that we see really commonly with our cases is that, let's say it's a female client, male abuser, and the female client applicant consents to vaginal sex, but doesn't consent to anal sex or other types of sexual activities, and they're forced to do so, forcibly held while they're being raped. Those are common fact patterns. A lot of people don't want to admit it, but those are things that we see often in our cases. Threats to deport somebody. I used to hear that a lot when I was growing up, from my dad, who's from New York, towards my mom. And, it can be really, really scary. And it can be really scary. And a lot of my clients talk about how they feel when their abuser is constantly threatening to deport them or take away their kids or everything that they've worked for. It can be very, very frightening for people to deal with. Emotional and psychological abuse are real. Insulting, yelling, making someone feel like they're going to get hit or hurt, intimidating somebody, financial abuse. All of these things are real, but there has to be an ability to distinguish everyday problems that everyone has. I have them. Your neighbor probably has them. Everyone has them. And distinguishing those everyday problems from what is actually abuse. And be careful, mi gente, because USCIS is cracking down on this. They're putting more resources. They're looking into these facts. And if you can't back them up, especially if you have an attorney, and this is crazy, but I guess people get prosecuted for it. So I guess it does happen. If you have an attorney that tells you to lie, to exaggerate, to produce fraudulent evidence, or even a notario that tells you to lie, exagerar, echar crema en los tacos, like us Mexicans say, you better be careful, because at some point they're going to get caught. And again, the penalty is not just getting your case denied. The penalty is not just having a bar, un castigo con inmigración, a bar with immigration. The penalty is jail time, realistically. Immigration fraud is a serious offense that we all have to be careful with. So, ojo, mi gente, they are cracking down more on that. I see some questions, so let's go ahead and answer some questions. Abogada, ¿podía arreglar una persona si tuve un asalto en 2013, pero esa persona tiene 2 DUI, pero pagó todo, él hizo todo lo que se le ordenó con la corte? Ok, si tiene 2 DUI, hay una ley que posiblemente si lo pasan en ley le puede afectar esos tipos de casos. Si tienes un DUI con el asalto, me imagino que lo que me estás diciendo es que usted fue víctima de un asalto. Entonces, si tienes el reporte policial, podías consultar con un abogado de inmigración a través de la visa U. La visa U es una visa humanitaria que le puede dar la forma para poder arreglar papeles. A ver. Una pregunta, teniendo permiso de trabajo por asilo, ¿lo pueden deportar? Sí, desafortunadamente, pero si tienes un caso de asilo pendiente y si estás agarrado de parte de ICE, podías decir que tienes miedo de regresar y si no has tenido tiempo para litigar su caso o presentar su caso en frente del juez, te tienen que dar por lo menos la entrevista de miedo creíble para que usted podías presentar su caso, sus miedos, su caso de asilo en frente de un juez. ¿Qué pasa si tengo falsa ciudadanía? Me imagino que la pregunta es qué pasaría si usted en un punto declaraste o si tienes el castigo por declarar que eres ciudadano americano cuando no eres. Déjeme hablar un poco de cómo funciona este castigo. Primeramente, solamente aplica en actos que pasó después del 30 de septiembre de 96. Recientemente tenía una clienta que tenía, ella no tenía ese castigo, pero ella entró a los Estados Unidos con el acta de nacimiento de un ciudadano americano, pero lo que le ayudé a esta clienta es que se pasó antes del 30 de septiembre de 96. So, tiene que pasar después del 30 de septiembre de 96, tiene que estar basado en usar los documentos de un ciudadano americano o declarar con su boca que eres ciudadano americano cuando no eres para obtener un beneficio federal o estatal. Ejemplos puede ser que entras a los Estados Unidos caminando diciendo US Citizen o entras a los Estados Unidos con pasaporte americano o acta de nacimiento de un ciudadano americano. O que usas los documentos de un ciudadano americano, generalmente un acta de nacimiento, pero también puede ser un pasaporte para aplicar para una licencia para manejar o para aplicar para un trabajo en el gobierno federal. O usas los documentos de un ciudadano americano para hacer los impuestos federales. Esos son ejemplos de donde el castigo puede pegar, como siempre, consulta con un abogado de inmigración. ¿Y qué hacemos si nos va a vencer la prima facie? Si le va a vencer la prima facie, de forma automática, UCI se está renovando la prima facie. ¿Qué tal una pregunta más? Si tengo una petición de ajustar de estatus I-130, ¿qué pasaría si soy detenido por ICE? Este puede ser difícil porque la I-130 no te da tanto protección y ahora mismo basado en una decisión de el Board of Immigration Appeals, la Corte de Apelación de Inmigración, si uno ha entrado a los Estados Unidos de forma ilegal y obviamente con esta pregunta no sé la forma que usted entró, uno no tiene el derecho para pedir una fianza. Entonces, ¿qué puedes hacer? Hay ciertos remedios que puedes pelear en los cortes de inmigración. Un remedio que estoy hablando de mucho es también usar las cortes federales. Hay un tipo de queja que se llama una queja mandamus. Es una queja, demanda contra UCIS donde el gobierno, donde dices, pues ya, toma una decisión de mi caso. Y obviamente hay más elementos que uno tiene que revisar, pero ese tipo de litigación te puede ayudar para recibir una decisión de la petición de forma más rápido para que a lo mejor si tienes la forma para hacer un ajuste de estatus aquí dentro de los Estados Unidos, puedes hacerlo antes de la deportación. O si desafortunadamente estás deportado, a lo mejor por lo menos le puede cortar el tiempo de espera que te vas a tener afuera de los Estados Unidos. Bueno, pues mi gente, espero que esta información le haya ayudado. Que Diosito me los bendiga. Buen día.